Hey Stephanie, good morning. Thank you so much for joining.
How are you? Thank you so much for having me.
I'm doing awesome. Awesome. Cool, cool. So, real quick, within the last week, I think we had the House pass the new bill, right? To support the quick processing of GCs. Could you please throw some light?
So yeah, the House has passed the highly skilled workers bill, which should be beneficial to really anybody, because what it does is essentially take what is now a 7% worldwide limitation on immigrant visas and increases that to 15%. So in particular, what you'll see is for countries like India or China or the Philippines, where there's a backlog, for instance, we're waiting for EB3 and EB2 for 2009 right now. So now that with the backlog, that should help the backlog. How much remains to be seen? Right. I'm always a bit skeptical because, we hear, and I know it's been highly touted, for instance, in India papers, because I've been watching that if this is going to be like some big dream, that it's going to change everything. I wouldn't expect it to change everything. I really wouldn't. But reasonable expectation is that if you increase by 8% the available immigrant visas, then you should see that 2009 EB2, EB3 number to at least move to 2011 or 12.
Absolutely.
Roughly, and I'm guessing, right? Because you don't know how many numbers are between 2009 and 2012.
Right.
You should also see some movement in EB1, which is now 2015. I should mention EB1 should be at 2017 by this October 2019. The State Department has said their goal is to get it to 2017, to bring it back up to November 2017 by, say, October or November of 2019. Gotcha. That cutoff date. So let's say we do get this bill passed through the Senate. And by the way, all indications are that this bill should pass the Senate. If this bill passes the Senate and they promulgate the rule, remember they still have to promulgate the rule before we actually start feeling the effects. I think what you'll see is an immediate boost, right? We'll see the numbers move forward, fairly rapidly, and then as people file against those numbers, you'll see those numbers fall off again. So I guess as you watch this bill go through Congress and the Senate passes it. And again, keep in mind that because the Senate passes it doesn't mean it's a rule that day. It means that now USCIS and Department of Homeland Security can now promulgate the rule on how they're going to implement that.
Gotcha.
So that's going to take some time. I'll give you an example. The H4EAD, they've been promulgating that rule for quite some time. They had to write it. Now it's still stuck in the Office of Management and Budget now since I think late March or early April.
Okay.
And so how that bill is implemented may take some time, maybe even a year, but every indication is that it's going to pass. So be patient. It should help. It's not going to be a panacea though.
Gotcha. All right. Let me ask you a follow-up question on that. You mentioned something about EB1, right? Is there any possibility or special stipulations where you can port your EB2 into EB1? Is there any category like that?
Not really. Not really. I don't know why you'd want to do that. It would have to be a same or similar position. Portability, EB2 to EB1 would be difficult. Are you thinking about extraordinary ability? Porting to an extraordinary ability?
Yeah, someone in their job who's now managing international teams, teams in multiple countries. So would that be good enough to port their EB2 into EB1?
If you are porting from EB2 to EB1 in the EB1C category, manager executive, then you have to show that you were a manager or an executive at your foreign employer for at least a year. So not just that because you're managing, like for instance, if you go from h1b to L1A in the United States, you can do that because you came for a technical role and now you're a manager. There's no requirement under the L1A that you serve in a managerial position abroad. You can serve in an executive level position, a managerial, or specialized knowledge. So you can be in a specialized knowledge position and then, come here as an H1B and then become a manager later and go to an L1A. But that doesn't mean that qualifies you for EB1C. Under EB1C, you have to be a manager specifically or an executive in India. And quite simply, because an H1B is usually here for quite some time, 9-10 years sometimes, right? At minimum of 6, right? In most, in the backlog countries. If you're under EB2 or EB3, the chances are 6, 7, 8, or 9 years ago, you were not a manager before you came here. Say if you're in India chargeability. So don't go back and then try to pretend like you were a manager, right? And try to make yourself eligible for EB1, because it just doesn't work. The documentation's not there. It's not true. Even if you were a lead, USCIS knows that as a supervisor, you're not a manager in most cases, as a technical lead, for instance. So those very seldom work. So portability would be difficult, aside from whether or not you can do it asking for that portability. I doubt that many people would qualify for portability under that category, because usually on an H1B or an EB2, EB3, you are kind of stuck with the position that's been petitioned for you. And almost always those are technical positions or engineering positions or accounting positions or something like that, that don't relate to the managerial. So that portability, even from EB2 to EB3, requires you to show that you're in a same or similar position.
Gotcha.
And it's not likely that you'd be able to show that. And again, I don't know the specific answer about whether or not you can port. I think theoretically you can port from EB2 to EB1, your priority date. The problem is it has to be a same or similar position. And I'm betting that the EB2 or EB3 position in many, many circumstances does not list you as a manager.
True.
Right? To qualify you for EB.
Yeah, definitely. I agree. And then the question is more about someone who's on H1B, someone like me who's on H1B now got promoted to a manager, right? Here in US, and then has been managing teams offshore back in India and also here. Would that qualify?
If you can show it, then we should be able to qualify it.
So the employer is in US, right? So the employer is American employer, and then they don't have any offshore presence. But again, he's full-time on H1B, now got promoted to a...
Yeah, and I have to check that, because actually I have personally never had to port from EB2 to EB1.
Very true.
Yeah, because generally, it's a very narrow set of individuals who would qualify, let's say.
Yes. The reason I'm asking this is I personally have so many friends who are very hardworking, and then they are now in a managerial position by role, not just by the responsibilities and duties, right? And then they're on H1B, they're with a full-time with the employer, but because of the vendors, how they work and all that, that's how this employer has offshore presence, not a direct company like a sister company, but again, it's a vendor system who's been managing. So maybe that will qualify.
So it won't qualify in that circumstance, because in order to qualify for EB1, you have to be employed by a branch, subsidiary, or affiliate of your U.S. employer. So your foreign qualifying employment has to have been with a branch, subsidiary, or affiliate. So if your company, for instance, acquired that company, then yes, you could do it. So if they acquired that company, then your experience abroad would be imputed on the new company, in essence, right?
Vendors don't qualify in this case.
Exactly. This would not qualify. Vendor would not qualify. It's not really a sister company or affiliate.
Right. Got you. I appreciate that. Thank you for answering that. And then the other question I have is, some of our friends are really pooling their resources for EB5 investor visa. Can I continue?
Sorry about that. I was just getting more light on me here.
That would be good too.
Yeah, you mentioned EB5.
Yes, let me ask you that question so we can edit this. Sorry about that. So about EB5, yeah, some of our friends are really interested and considering this EB5 investment opportunity. But again, having given the timelines with how the bill and rule would take, would you still advise them to go ahead and bring those resources in the next 1 or 2 years if they're planning for that? Would you still advise that?
EB5 is a tough choice because, number one, the minimum investment is $500,000. So you invest $500,000 in the U.S., and that's only as long as those targeted employment areas last, right? There is a lot of talk in Congress. I haven't seen the bill written yet and finalized, but to increase that minimum to, we've heard a few numbers: $1,025,000, $1.4 million, for the baseline investment, and then $975,000, let's say, for the minimum investment, and then also narrowing that definition. So what allows us, EB-5 requires $1 million, but what allows us to invest 500,000 is if you invest in an enterprise that is in a targeted employment area. So that targeted employment area definition will be, if the bill is passed, or if a bill is introduced, everything that we're hearing from Congress is that they'll narrow that considerably. So even though today you might be able to do that 500,000, we don't know where that will be or how it will impact your green card in 2 or 3 years, because processing time is at least 2 years right now.
Right.
For an EB-5.
Right.
So, and then for India, for instance, well, China is backlogged. I mean, China can barely get in on EB-5s, but for India, even EB-5 will probably be backlogged in the near future.
Sure.
So even though you'll wait 2 years, now you're in the same situation, right? Where you may end up, the highly skilled worker bill will take care of this a little bit, but you still may end up backlogged, even though you've invested $500,000 or $1 million.
Sure.
Because EB-5 for India, because of demand, will probably be backlogged again.
Yeah.
We don't know how long. It depends on how that highly skilled worker bill really impacts, because that will impact the EB-5s as well and help the EB-5s. But I wouldn't, again, not a panacea, right? If you invest your money and you're literally tying up $1 million for 5 years, in essence, probably a little longer, because you need to have your investment made. In order to file, you're going to make an investment. It's going to be tied up.
Yep.
Right? So it's going to take 2 years just to process the case. Then you come as a conditional resident. Let's say it takes 2.5 years because they have to do the immigrant visa process. So 2.5 to 3 years to just get here on a conditional residency. Then you have to be here for 2 more years. And if you've invested in a regional center or an individual investment, either one, that business has to still be working. You still have to be employing 10 workers per investor. And then that's going to process after 2 years. You're going to file for to remove the conditions to your green card, and it's going to take again another couple of years. So, really, you're in the U.S. with a green card after a couple of years, but it's not something that's going to be quick, even for India, even under the highly skilled worker bill. So a lot of people, that's just not palatable to have their money tied up for potentially 7 years, $1 million tied up in, say, a regional center or something like that.
Yeah.
So I would just caution anyone. I love the EB-5, right? For the purpose of what it is there's no commitment. If I'm not ready to come yet, I see a lot of is middle-aged parents who say, I want my children to go to school in the United States and have a green card in the United States. So they'll make the investment on behalf of the child. The child will actually be the investor. And then who cares, right? They're going to finish their school in India or in another country and then come to the U.S. under 5. That's a great program. If I'm 50 years old and I'm investing right now in the United States, and maybe I'm looking at it as post-retirement, I'm coming under the EB-5, that might also be beneficial. But you have to have that liquidity to invest.
Definitely, absolutely.
And let it be tied up for 5 to 7 years, right? Possibly longer.
Yeah.
So that's tough with the EB-5. If somebody really wants to invest in the United States and wants to start a business, I prefer the eVisa. And I know we talked about that a little bit on the last video, where the eVisa, India, for instance, you have to be from an eVisa, e-treaty country. So India is not an e-treaty country. And we'll talk about India specifically because that's generally, the market, the highest amount of h1bs are from India. So, and it's a good example of a country that's not e-eligible, right, on its face. But an Indian national can obtain citizenship in, say, Grenada. And based on the Grenada citizenship, they can come into the United States as an e-visa holder, as an investor, or as a treaty trader, usually as an investor. The investment there is much less than $1 million because they need to invest. All these e-visa countries have different citizenship requirements, but I think in Grenada they have a couple different programs where it's like $350,000 you invest, you become a Grenadan citizen. It's a relatively short period to become a citizen. And then, of course, India is going to make you give up your Indian citizenship when you become a citizen of Grenada. But then you apply for an e-visa to come into the United States. Just a word of caution about that. The e-visa is a non-immigrant visa, and it does not lead to a green card. So, but that may change in the future. But, if you give up your Indian citizenship and become a citizen of Grenada, and then you come in on an e-visa, what happens if your business fails? And then where are you going to go back to? How are you going to get your Indian citizenship back? These are factors to consider.
Right.
Still a viable option for somebody who says, no, absolutely, I have this great. I want to live long-term in the United States under an investor visa and come that way. And it's a much it's a much lower investment, except for the fact that you're giving up your Indian citizenship.
Right.
It's a much lower investment than it would be on an EB-5, and it's much quicker, by the way. I think Grenada processes these citizenships in just a matter of months.
Okay.
An e-visa you can obtain in, realistically, it takes about 8 to 10 weeks to process in most pulse, maybe a little longer. So really, realistically, within a year, you could be here under an E. So for a lot of people, especially people who've lived in the United States long-term on an H1B, that may be a viable option because, frankly, if you've lived in the U.S. for 9 or 10 years on an H1B and you just filed your green card 3 or 4 years ago, even after the highly skilled worker bill is passed, you're probably still waiting 4 or 5 more years.
Okay.
Whereas you could be here under, e-visa, for instance, under this scheme, and running your own business, not tied to that H1B. I mean, the big problem with the H1B right now, I think you'll agree, is you're tied to an employer, and increasingly with the RFE rate increasing, it's almost thwarting the intent of immigration laws. The intent of immigration laws is that you not be kind of sworn into servitude, in essence. But frankly, when you're on an H1B, you're stuck with that employer, right?
Yeah.
You're at their mercy. They own the petition. They're answering the request for evidence. If they don't do a good job answering the request for evidence, or the contracts aren't available for the end client if you're doing a third-party client, or you mentioned a vendor relationship, if the vendor won't disclose the relationship, if anything that goes wrong in the middle of that process, you could be without an H1B. And after living here for several years, now you're suddenly leaving. Your kids are in school here, middle of the school year. I've seen it all. Your spouse is pregnant. Kids are in school, or even, some children have special needs. Some children have medical issues that are being treated in the United States. And then suddenly the request for evidence is denied, or your H1B is revoked, and you're out. So in that sense, the H1B and immigration laws as a whole in the U.S. were just formulated to avoid indentured servitude, right? In a sense, you're almost stuck with that employer. And even though some H1Bs, many H1Bs just love their work and are very happy to be working for their employer, you're beholden to them and the processes that they're going to take out. I've seen executives in very high levels who won't change positions because their H1B is there and their perm is in process, right? So, that's a real consideration when you're considering the alternative of, say, an e-visa and giving up your Indian citizenship.
That's awesome. That's definitely really appreciate all that, explaining all that process. But let me ask you one question, though. So keeping the H1B, this is all a possibility, right?
Sure,
and, filing for Grenada citizenship and then applying for e-visa. So really what we are addressing is you will keep your H1B, you will report to your job, but if you have any other ideas, this is what you can file for e-visa, run your business that way. So you can be on multiple visas. Is that right?
You can only be on one visa at a time in the United States, and it's status. So the visa gets you entry to the U.S., and then you're in one status at a time in the U.S.
Okay.
So you come in an e-visa, and your purpose is to run that business.
Okay.
Now, you have work authorization. You can run that business and still work for another employer, but your job, your goal is to cultivate that business, because every 2 years or so, you're going to have to renew that e-visa, and you're going to have to renew based on the growth of that business. And that sometimes the life cycle of a business is longer. So you're going to have to really, invest a substantial portion of your time. And the e-visa contemplates that you'll be spending the majority of your time on that business, or really your time to grow that business. Because that's the purpose of it, right?
Yes,
is to come in and cultivate an investment and to build jobs for U.S. citizens. That's the entire purpose of the e-visa. It's all about promoting investment in the United States.
Yeah, you will invest, you will promote the business, but you are not bound to that business. You can still, work.
You can take on other jobs, or if it's a consulting business, you can work for another employer and bring in other consulting jobs, and yeah, if you have to, you have to.
That's
right?
awesome. That's awesome. Can I ask a couple of more questions on that?
Mhm.
So how does it work for the family, right? So if I'm in that particular situation, how does it work for my wife or kids? So right now, we're on H1b, H4, and then kids are citizens. So how does that work? How does it translate?
So the spouse gets work authorization. The children
The
do.
same
The
application.
spouse gets work authorization and a social. The children do not get work authorization or a social. So if you have to file for a visa for the child, can you still hear me?
Yes, I can hear you.
If you
Children
file for,
are already citizens, right? So that doesn't affect any of that, is it?
what's that?
So children are already citizens, right?
Oh, if the children are citizens, then there's no issue there. Yeah, no issue at all. Mhm.
Okay.
Now, the only issue you might have with that, and this kind of gets into the trenches of the eVisa, is an eVisa is temporary, right? Even though you can essentially indefinitely extend an eVisa to continue to work in the United States, it is a temporary option.
Sure.
So you have to actually sign a paper saying that you intend to depart the United States after your investment is over, right?
Okay.
So the eVisa officer at the port of at the consulate may also consider the fact that you've been living in the United States long term, and that your children are U.S. citizens in determining whether or not that eVisa will really be temporary. And of course, there are explanations to this, right?
Yes.
The explanations would be, look, once my children graduate high school, I'm leaving. I'm running this business for the next 10 years. My goal is to get this business to this level, hire U.S. workers to manage it. Gotcha. Eventually, when I get the business, up to a certain point, then I'm going back to my home country.
That should be your intent, though.
That's your intent. It actually is a stated intent. You have to sign a paper saying that.
Gotcha. Okay.
Yeah.
And how does that? Yeah, so let's say the business has been really good, and then you really hire American employees to manage that. You can still enjoy the fruits of the business.
Yeah, absolutely.
And then is there a possibility to still file for a green card or?
Yeah, from abroad, yeah, you can do that. But I just want to go back to where you talked about, can I have an eVisa and still work in my H1B job? The real big tenet of the eVisa is that you're coming to the United States to just solely develop that business.
That's true.
You can't go to the consulate and say, I'm going to invest in this business and I'm going to keep my H1B job. Not going to work, because your job is to cultivate that business. That is, develop and direct the investment enterprise. That's your job here.
Yeah.
So if that means that it's the type of business that also caters to a vendor relationship or something like that, then that might work, but you just have to be very careful there. So
I understand. Yeah, there is very thin line. I mean, every case scenario is different. So we got to understand what business and then how you're going to bring in revenue for that business. Mm-hmm. All right. Thank you for addressing that. And how does that situation, once you're on eVisa, now you are on a H1B, now you are on eVisa, managing your own business, and then it's temporary for 2 years. But again, let's say it has, so how does that particular situation go into a green card processing? So your I-140, you should let it go.
No, you don't actually have to let it go. There are circumstances where you can file a form and still avail yourself of that visa. I generally of the perm and the I-140 at a later date. So your intent when you come in on the eVisa, and this kind of gets into like individual advice, but if your intent to grow that eVisa business and the green card is so far in the future, first of all, if you have a green card application pending with USCIS or you have an approved I-140, then you're still going to have to, explain to the consular officer how your job is temporary and just say, look, I'm tired of waiting. I want to run my own business. This is going to be my sole, goal while I'm in the United States, my intent. But you have to get over that intent issue, and that really takes advice of counsel. So I would say if you have that specific issue, then you need to talk to counsel, because there are ways around it, right? Maybe you intend to immigrant visa process. You're going to run your eVisa business and you're going to grow it for the next 10 years, because if you're filing in 2019 a perm and an I-140, you're going to wait 10 years, maybe less, with the new highly skilled worker bill, but let's say 10 years. It might take you 5 or 6 years to establish a solid business in the U.S. under the E. And then later on, you may intend to immigrate on the green card. I generally like to do those offshore. And that's something where if somebody's in that situation, they should contact counsel and really discuss their options, because it takes some strategy and plan.
But it still falls in, which category does it fall? If an investor from offshore files for his business in US, right? He comes here, he runs his business now. Which category of green card does he fall under?
Well, there's no direct green card from E to an employment-based green card. There's no direct green card.
Okay.
And that would be problematic. Potentially, you could port that priority date from another employer over to the new employer and then immigrant visa process later. We've done it, for instance, under the EB1 category very, very easily, where we've had people come on eVisa and then file EB1 based on their previous employment, abroad. And then they've left and gotten immigrant visa processing and then come back in the United States as a green card holder. So I would say it has to be a separate qualification and not based on the eVisa itself. At this point, I'd say Congress has been talking, and it's probably widespread support for allowing eVisa holders eventually to have a pathway to a green card. But right now you don't. It's a temporary visa, and you have to show that you're going to, your intent is to come here and establish the enterprise, and then at some point depart.
Okay.
So that immigrant intent issue becomes really sticky. So I would say if somebody's thinking of doing this, to just really sit down and strategize with the Immigration Council.
Absolutely. I mean, it's not a very viable option for someone on H1B and already in US. Do you agree?
It can be if you plan it the correct way. Yes. If you want to make an investment and leave your H1B employer and start a new business, then it can be. You can't do that on H1B. We talked about that in the previous panel, but you cannot, start a business and have an active role in that business as an H1B holder unless you file a concurrent H1B for that new business. Typically, the business isn't sufficient to support an H1B immediately, especially if it's just one person running a business. But it has to be a passive investment while you're on your H1B. But if you're on your H1B and you say, hey, I've saved $150,000, for instance, and I want to start my own business, and I have a business plan, I have a really solid investment that I want to make, then potentially the eVisa route works for you, but it requires you to depart the United States, apply for an eVisa abroad. In most cases, let me correct that. In most cases, it requires you to depart the United States, apply for an eVisa abroad, and come back in. You can change status in the United States. Let's say you're an Indian national, you get citizenship in Grenada. You want to start your own business, you have $100,000 or so, you apply for an eVisa, you can change status in the US. The reason I don't like that, it's just kind of my preference, absolutely, it's actually probably easier to change status in the United States in terms of how the cases are adjudicated. But the way the eVisa works is if I change status in the United States and I get 2 years, let's say, on my eVisa, I can't travel outside the US. It's not like an H1B where all I have to do is travel outside and get my visa stamped and come back in. Anytime you travel after changing status from within the United States, you go outside the US, you have to essentially apply with the consulate for a new eVisa, and you risk getting denied at that point. My preference is, because you're going to want to travel. Somebody's going to pass away in your family. Something's going to happen. You need that visa stamped in your passport. And the eVisa, again, I stress this, it works differently from the L1 and the H1B. If you're on L1 or H1B in the United States and you want to get a new visa stamp, you just get your approval from in the US, you make a consular appointment, you go in, and if you're eligible for the drop box, like you're doing an extension, you just file with the consulate and you get your visa stamp and you can come back in. Again, the eVisa, if I change status in the US from H1B to eVisa, I can't do that. In essence, if I 6 months later decide I have to travel because someone passes away or I have business abroad, even business in Canada or Mexico, right? Now I have to apply for a brand new eVisa. It's a brand new packet. It's costly. It risks denial at the consulate. I mean, for me, it's just better to get that visa stamp straight up. Every case, I would say every case that I've done where somebody insisted on changing status from within the United States, from visitor to eVisa, for instance, or H1B to eVisa, or L1 to eVisa, every time those people have had to travel because of an emergency and couldn't because they did not have the visa stamp. And again, visa stamping for an E requires a complete packet, probably 8 to 10 weeks of waiting for a consular appointment and for the eVisa officer to review it. and it has its risks. You're getting your case adjudicated fresh.
Gotcha.
So a lot to think about if you're thinking about the eVisa strategy. You definitely need to seek the advice of counsel.
Definitely, but definitely that's something that some of our friends can consider, and then obviously we need to talk to professionals like you, case by case basis. And one more thing, maybe we are past our timeline today, but do you have a couple of minutes?
Yeah, sure.
So about something like Airbnb, right? Can our friends start a Airbnb? It's not a business basically, but it's a property that they have or something like that. It's not a property management where they will be involved on a day-to-day basis. Just Airbnb. Can they still be involved with it?
They can be involved in it passively. So they can't be going and cleaning the house, right? I mean, that kind of thing. And they have to also talk to a tax advisor about the tax implications. So, rental real estate income already carries a tax implication. But being a foreign national owning those real estate assets could also carry an additional tax implication.
Gotcha. Absolutely. Yeah, I have something set up with Umang as well, so I'll definitely bring this up with him.
Great.
Thank you so much, Stephanie. I think those are the 3 or 4 questions I have for today.
All right, Bobby, I think it was good.
Yep, definitely. I appreciate your time. Thank you so much.
Thank you so much. You have a great day.
Have a good one. Bye-bye.